Welcome everybody again, and it's a pleasure to be with you one more time for our workshop today, which focuses on the legal and administrative aspects of voluntary assisted dying. We've got a great group of speakers and panel for you again today, and we're really looking forward to another vigorous conversation. As previously, I'd like to acknowledge the traditional custodians of the various lands on which we're sitting at the moment, and to express my respect for the elders past and present. As with yesterday, we've discussed the way in which we'll conduct this session. The aim is for it to be inclusive and interactive. And I've asked the speakers to limit their talks so that they have the form of, as I put it last night, provocations, rather than fully developed and elaborated arguments, with the aim that if there are additional points to be made, they can be developed in the discussion that follows. We have a couple of additional panel members with us tonight, Geetanjali Lamba and Deb Hartley, and they will no doubt introduce themselves during the course of their of the discussion. I've, as yesterday, asked the panel members to think of their role as one as to stimulate the conversation. You can feel free to jump in if you've got something to say, but we're not necessarily going to work through every single person on the screen one by one. So with that, I'd like to go to our first speaker, who, like last night, is Camille La Brooy. Camille's the project coordinator, and Camille's going to give us a little bit of an overview of where we stand in relation to the data relating to the legal and administrative issues. Thanks, Camille.
Thanks, Paul. So hi, everyone. Thanks again for joining us, and it's great to see so many people joining us on all the 3 days so far. So again, I'm going to be presenting just a few of the key findings from the project, and today I'll be just presenting some of the key things from on this particular workshop. And for those of you who didn't join us yesterday, there are both qualitative and quantitative aspects to the project. As I have a little bit more time today, and I was quite limited yesterday, I might go through a little bit of the methods. So our methods involved interviewing 67 healthcare professionals, 22 of whom were interviewed a second time, approximately a year after being interviewed initially, in order to ascertain whether views had changed and observations had changed over time. 45 carers were also interviewed, 33 of whom participated in the quantitative aspect of the project as well, involving surveys which looked at standardised mood, burnout, burden of care scales. In addition, 36 patients were interviewed, 21 of whom also participated in the quantitative aspect of the project, and these instruments examined quality of life, performance, status, mood, anxiety, and depression. And so we also undertook a systematic review of the literature, and this involved looking at studies in English published in the 5 years preceding VAD's legalisation in Victoria, and involved jurisdictions that had legalised their own version of a euthanasia law. And we have used the findings of this systematic review along with our findings from the project's data gathering aspects to develop an instrument that can evaluate VAD in other jurisdictions in Australia. And we've so far put together a series of variables across 3 domains, that's the micro, the meso, and the macro levels, and a number of instrument questions that can be used to evaluate various aspects of the law. So just to summarise a few of our key findings with respect to the legal and administrative aspects of VAD. And of course, as I mentioned, I'm probably choosing some potentially just provocative issues of the many legal and administrative issues that we had. But I'd like to as I said, focus on some of these issues underpinning the workability of the law. And namely, many of our participants spoke about the safeguards and how they had adverse consequences and potentially obstructed access to VAD. So, for example, Section 8 prohibition on healthcare professionals initiating discussion of VAD was felt to be problematic by a large number of interviewees. And even more problematic was the federal carrier law, which was felt to create huge logistic issues and delays with the requirement of having to have face-to-face meetings and preventing telehealth. And this was particularly problematic for rural patients, especially with COVID-19 ravaging as it currently is. Also, unlike in Western Australia, for example, there's no clear legal demarcation between suicide and VAD. And as a result, there seemed to be confusion and uncertainty created with the stigma of suicide distorting people's decision-making. So often people wanting, the perception of their decision-making rather. And so often people wanting to go through VAD were pathologised as having depression or potentially having a mental illness for wanting to request VAD. So in a nutshell, the legal requirements led to highly bureaucratised processes for clinicians, family members and carers. And so some of the findings that I think would be good to have a discussion about in the open forum later are on this slide as follows. So we observed that understanding of various details and purposes of the safeguards is generally poor among clinicians, let alone patients and carers. And also we found that although there are examples of breaches of various provisions of the law, there appears not to be any clear processes to respond to such breaches. So for example, patients mentioned being told about VAD for the first time by clinicians, etc. So I guess for me, this raises questions about how we mitigate errors and prevent the law being broken, or whether the law should be revised so that it's upheld. So that's all from me for the moment. Thank you.
Thanks very much, Camille. As we've emphasised in the previous sessions, one of the goals of our project is to develop a set of recommendations for how the Victorian legislation can be refined. So it's useful for us to think both about the problems, but also about other approaches that are being taken elsewhere. So the next speaker is Cameron Stewart. Cameron's a lawyer and Deputy Dean of the Faculty of Law at Sydney University. Is that correct, Cameron?
I've very gratefully been relieved of my responsibilities as Deputy Dean. So,
okay. So you've been Dean and Deputy Dean.
I've been, yeah, undeanified.
Okay, thanks, Cameron.
Thanks, Paul. So just to follow on directly from Camilla's presentation, we very quickly, as soon as the grant started, actually, I think it might have been our first publication, looked closely at the problem of the carrier laws and the definition of what suicide-related materials was. So to contextualise this legally, back in, I think it was 2002, the federal government made some changes to the criminal code. So the federal government has its own criminal code. Mostly criminal law is done at the state level, but there is a federal criminal code. And they were particularly concerned about the behaviours of Philip Nitschke, who was threatening to do things such as set up overseas websites and set up boats in international waters and things like that. And so in response to particularly his use of the internet to present materials, they passed they introduced some 2 new sections of crimes into the criminal code, and they basically make it an offence for someone to use a carrier service, which is basically, you know, the internet, to provide material or to access it, to use it to transmit material, and distribute it or make it otherwise available. That material was basically had to be connected with the sort of counselling or inciting or giving advice about how to commit suicide. Now, interestingly, the definition of suicide was not provided, so there's no federal definition. And in those circumstances, we would normally then go and fall back to common law definitions of suicide. And common law definitions of suicide are, very old because suicide was decriminalised during the 20th century. But the notion is basically an intentional act of self-destruction, which is, sometimes they use Latin to describe it, which would be a felo de se, a felony against yourself. So it's very clear that these provisions were looking at types of behaviour which was in parallel with the prohibitions on assisted suicide that exist at the state level, and they were looking at people who were looking to deliberately self-harm. They weren't intended, and were never intended, to control or to affect legalised systems of voluntary assisted dying. And remember too, at this point, the the Northern Territory scheme had been overtaken by federal laws, and this is possible because the territories are subject to federal jurisdiction and on any matter, whereas the states have their own powers and there's limits on what the federal government can do to states. So that's why generally the voluntary assisted dying laws have come through at the state level, because it's the appropriate place for them to be implemented. One of the things, as Camille has said, one of the things that's kind of lacking in the Victorian legislation is a very clear statement that a voluntary assisted death is not suicide. There are other provisions though, and I would argue, and we did in our article, that if you read the legislation carefully throughout, there's lots of examples of an intention on the part of the Victorian Parliament to distinguish voluntary assisted dying from suicide. And it would be lovely to have a very clear statement, as we have in other jurisdictions like in Western Australia. But I still don't think it's a death to the argument that the Parliament was intending for voluntary assisted death to be a very different thing from a suicide. Does that then mean that the federal laws can be overturned by state laws? Not quite, but I would argue that these federal laws, as I said before, they were never intended at all to apply to these types of situations. And additionally, if the federal government is using a state-based definition of suicide and the state itself distinguishes between VAD and suicide, then that's how the federal code should also be interpreted. So our arguments were that we did not think it was the right answer to say that the federal laws restricted or prevented doctors from using the internet and using telecommunication services in cases of VAD. So we put that argument strongly. Not everyone agrees with that, of course, but that was our approach. So what ways do we have to go forward? Because at the moment, all of the states are still not allowing the use of telecommunications in that way. Well, one answer is legal professionals have been calling for reform here. The Law Council of Australia has asked for the federal government to make changes to make it clear that these laws aren't meant to apply. Obviously, the previous government wasn't interested in that and made no efforts to make any changes. And the current government, at least from what I've been able to find, is interested in considering at least getting legal advice on these issues, but it hasn't committed yet fully to making changes. And you can understand their legislative agenda is pretty chockers at the moment, although it would be and I can understand too not wanting to be derailed by a whole euthanasia debate at the federal level. But the argument would be, we're not doing that. We're just looking at this very narrow question, but it can always be difficult to keep the debates contained, especially when it's a hot button issue. An alternative and potential remedy may be to seek a declaratory action in the Supreme Court or in the federal court. Both of those courts have a jurisdiction to make declarations about what the law is and whether a particular action is legal. And so with a test case, one that would be carefully prepared, you could approach either jurisdiction and say, we'd like a declaration to say that this doesn't offend the federal law. And once that declaration is made, it gives a sort of binding interpretation on what the federal law is supposed to do. Now that could go either way, because that's always the way of litigation. But I would say that it's a win to get an answer in either direction. If the answer is that it is prohibited, then we can have a clear case of going to the federal minister and saying, you need to fix this. This is ridiculous. Whereas if we win, then we don't need to go to the federal government. We have a lovely declaration that informs us the way the two laws, state and federal laws, are supposed to work together. I imagine that it would be very easy to get funding for that from interested parties. And I also imagine that the Attorneys General would be very interested in joining in that action, because this pretty much affects every state now. So I think that may be a way forward as well, if we find that there's a bit of a political blockage in terms of getting the current government to put this on their legislative agenda. Thanks, Paul.
Thank you very much, Cameron. It'll be good to come back to talk about this a bit later. Our third speaker is Ian Freckelton. Ian, thank you and welcome. Welcome and thank you for joining us. Ian is a Queen's Counsel who has been involved in multiple tribunals. He's a judge of the Supreme Court of Nauru and has many other achievements that you can read about in the biographies. Ian, thanks very much for joining us.
Thank you very much. I'm not able to share my overheads at the moment, so if you can enable that, that would be great. But
James, can you help with that?
It is enabled. If you have a problem, you can send it through to me and I can share on your behalf.
I've sent them through to Paul.
Oh, have you? Okay, then if that's the case, I will.
Let's not delay people. I'll start the process of talking about the issue. The matter arises in terms of the circumstances in which health practitioners are permitted to initiate discussions about voluntary assisted dying. That's not an easy conversation for anyone to have, and it can be hard for a person with a terminal illness to initiate that discussion. There can be any number of emotional and other impediments. That's it, thank you. Maybe we could go to a second one. To the person raising the subject themselves. Although once the matter is broached, it can be a relief to the person to have it in the open so that information can be provided and options discussed. So then moving to the next one, the politics of the Victorian legislation, I think, need to be acknowledged. Next one, and the legislation was very much a compromise, wasn't it? With the government at pains to reassure other politicians, the electorate generally, clinicians, everyone, that there was a multiplicity of safeguards in place and that there would not be the potential for abuse of the system. And what we've seen then and afterwards is almost a rivalry between states in terms of the assertion of sufficiency of safeguards. 68, I think, were claimed in the Victorian legislation, 102 in the Western Australian. That only goes to underscore the fact that politically, this was a difficult compromise in which it was incumbent upon the government to persuade everyone that all was in order and that persons would not be put under pressure to do that which they did not really want to do. So moving to the next one, please. Here's the Section 8 of the Victorian legislation. And as you can see in there, a registered health practitioner providing services or care to a person is precluded from two important things. The first is initiating discussion with the person, that is in substance about voluntary assisted dying. The second, in substance, suggesting voluntary assisted dying to the person. That leaves the practitioner able to discuss the matter, but only if the discussion has been initiated by the person themselves. So what we have is a preclusion upon raising the topic in any explicit way and a relegation of health practitioners to a responsive or reactive role. That's the A part in Section 8, subsection 1. The second part is a preclusion on any form of promotion of voluntary assisted dying as a solution to issues facing the individual. So moving to the next one, the second reading speech sheds relatively little light on the situation, but the words again are clear from the Minister in terms of the substance of Section 8 and the intention lying behind it, both in terms of oral communication to a patient and written as well. So moving to the next. What was said was that Clause 8 of the bill, as it then was, allows a practitioner to provide information. It's not intended that every single subsequent discussion be initiated by the patient. The intention is to protect people who may be open to suggestion or coercion, not to discourage open discussions. So that's the wording used by the Minister in the second reading speech, at pains not to require every conversation to be patient initiated, but the purpose of the phraseology in Section 8 being to protect people who may be open to either pressure or suggestion. Moving on to the next one then. The provisions are variable throughout Australia. They're largely similar in Victoria and South Australia. Moving to the next. However, they're different elsewhere. In Western Australia, Queensland and New South Wales, a medical practitioner can start those discussions, but they have to provide information about treatment and palliative care options. In Western Australia and Queensland, a nurse practitioner can do it. Next one, please. In Tasmania, all registered health practitioners can initiate the discussion. Again, they have an obligation in this instance to inform the person that a doctor is the best person to discuss voluntary assisted dying with. In New South Wales, there's another variant allowing healthcare workers, which is a broader category, to initiate the discussions, but again, the obligation to inform the person that they have palliative care and treatment options available, and they should talk about those with their treating doctor. Next one. In all of those 4 jurisdictions, a registered practitioner and other types of healthcare workers can provide information about voluntary assisted dying, but that's in response to a request for it. So moving along. The College of Physicians has generated a position statement about this complicated system, which is inconsistent from one jurisdiction to another, saying that the motivation to access voluntary assisted dying in terminally ill people is likely to reflect multi-dimensional distress in relation to end-of-life suffering. In addition to physical suffering, people may experience depression, anxiety, organic disorders, delirium, as well as psychological distress. The point being there, the highlighting by the college of the diverse sources of vulnerability on the part of the patients. And notably, the college stays away from this fraught issue. Unsurprisingly, because of course, all practitioners must comply with the law in their jurisdiction. Next one. So this is where things are left. We could all agree, I suspect, without reservation, that it is important that terminally ill patients not be pressured. But that's an easy thing to say. Pressure can come in different forms. It can be direct and indirect, and it can be objectively in existence, or it can be subjectively perceived. People do need to be able to make decisions about something so important, but they can only do so if they have the information which lets them make such decisions. And if they don't feel comfortable themselves with initiating such discussions, in Victoria and South Australia, the discussion doesn't happen. And so the hard issue here is whether that information should be provided, not in a way which constitutes any form of suggestion or pressure or overture, but in a way which enables discussion to be commenced. That could be constructed in one way or another by legislative provision. We can see that there are versions in other states. Others could be attempted, which distinguish between provision of information and any form of encouragement or suggestion on the part of a practitioner. What we could all probably agree upon is that there does need to be some control which precludes persons who may be vulnerable for a whole range of reasons being afflicted with any sort of pressure or perceiving in any reasonable way that they are being pressured. So the wording needs to be very carefully constructed. But at the moment, many authors and many commentators and many clinicians have expressed consternation about whether the Section 8 preclusion as it is drafted is inhibiting people who need information from receiving it, and therefore depriving a significant cohort of people who may well be eligible for voluntary assisted dying from being able to access it. Thank you, Paul.
Thank you very much, Ian. I'll stop sharing. Thank you. So we're now moving on to the last two speakers who are not lawyers, but clinicians. We're moving to Charlie Corke, who's an intensive care specialist. Charlie and Mitchell are both members of the Voluntary Assisted Dying Review Board in Victoria, and Charlie is a former acting chair of that board. Thanks, Charlie.
Hey, can you hear me?
Yes.
Excellent. Well, I thought everyone else would talk about the law, so I should talk about some administrative aspects. And the title I've got for you is Medicine Meets Bureaucracy. So when this first started, the whole approach was that this was an incredibly high risk situation, that the slow but short. So if you say that to a bureaucrat, they're going to be very slow and very sure. They definitely won't be hurried. If you try and hurry someone to do something very serious, they get upset. A veto by anybody blocks the progress, and everything has to be perfect. And we've had an enormous amount of things early on about names must be exactly the same, dates of birth must be exactly the same, addresses must be exactly the same, diagnoses must be exactly the same from the two doctors. So a very high bar that led to lots of things being sent back. And interestingly, I mean, there's a number of people in the world whose birth certificates have the wrong date of birth because their father wrote the wrong date of birth down on it, or their name was so horrible they've never used it. And so there are lots of things that you find in that. But later on, as a routine situation, it's efficiency in a routine situation is expected. It can be expedited. It's a consensus approach rather than a veto. And you're trying to be reasonable rather than utterly rigorous. And we're moved to that situation as the process has been working through. And I think that's a very positive thing. If I look at this is from last year's report. Our new report is just about to come out, but it's confidential at the moment, so I can't use it. So this is last year's report. And you can see that 13% of patients don't get a consulting assessment. And that's generally because they die before the second appointment. So from their first appointment, their first assessment to their second appointment, they die. So that's a 13% drop off, which is unfortunate. Second thing is that 15% don't progress from a completed assessments to a permit. So they've had both assessments done, but they don't get to a permit. So it's another 15% drop off. And then there's another drop off of over 100 patients between the permit being granted and the medication being dispensed. So so when we add all that together, it's a halving between the first assessment and the medication. So half the patients don't get through or didn't. I think things are now better for reasons that I've just explained to you. I just did a little review here of the last 20 patients that have gone through that we've reviewed. And looking at this, so the blue line is the first assessment, the green line is the second assessment. And I think you can see from that that the doctors actually get on with it pretty quickly, and that within, mostly within a week, the patients have had their second assessment. And given how long it takes you to get an appointment with a specialist, you can see that the specialists are actually expediting. These patients are jumping the queue hugely in order to get through the system with the second doctor. We then look at the permit application, sorry, the final request, and then the permit application, and then the permit grant. And you can see here that the white space here, there's a reasonable space between the second assessment and the final request. And then there's the process after that is reasonably quick. Look at this one here. It took a long time to get there, but as soon as the final request and the permit application were put in, the department responded very quickly. So you can see that as they get above 30 days or 25 days, the department's acting pretty quickly. But we've got these here, which are delays in getting the final request done. And there's some issues there that we could address. And some of the safeguards are some of the reasons why that's happening. And the workload for the small number of doctors who are doing it is also an issue. So the consumer feedback that we've had is that frequent reports of resistance to start the process by healthcare staff, and that many are near the terminal stage before. And the problem with that is that they get knocked back. They tell us that they're being knocked back, can't get the process started. And by the time it starts, they're pretty near dead. So it then becomes an enormous emergency. And that's not the way it was intended. It was intended to be a calm and quiet process, elective process that wasn't over urgent. So if we could get patients to start able to start the process, and our experience in the board is that the patients want to start and the medical profession doesn't let them. Applicants can't understand the delay in a process that they see as being very urgent. And we heard that from Camille the other night about how they're feeling that this is their end of life odyssey and they want to get it done, and they get very agitated about it. So starting late and then becoming very agitated is not the way that I think anybody wants this process to happen. So the two steps, I think, are early response to request and how we can help that to happen, particularly in the country, and then efficient process of the application when it actually comes in. My perception of success is that almost all eligible patients will get their medication. And then once they get it, we heard from Michael Dooley yesterday about how the patients take it as the pharmacists leave the house. I'm bothered about that because if they, that's a sign of desperation. I'd really like them to have it and sit on it and put it in the cupboard and keep it for at least a week. And that way I'd feel that they'd got it and they were able to have that time of feeling reassured that they had it, and then take it at their time of wanting it, rather than taking it later than they wanted to take it. And of course, we'd like rural patients to have equal access. And finally, Camille said, pointed out yesterday or the day before, that her feedback with the patients that feel that they respect conscientious objection. And I think she's right. Accepting of non-participation is widely accepted by patients. However, they're very upset by obstruction. So someone who will do nothing for them and blocks them, they're very upset about. And our feedback says they're very upset. They're even more upset by the removal or restriction of palliative care. And we've had a number of reports of this, where community palliative care are withdrawn from patients who talk about VAD, or their services they've had to move to other services. And they're very often distressed at being expelled from facilities, although sometimes they're so upset by the facility and the lack of sympathy and acceptance of them in that facility that the relationship's so broken down that it's reasonable that they want to get out because it's all fractured. But those things are really quite messages that we've had quite strongly from relatives in the feedback after VAD. And I finally just finish with this bit at the top. And patients do think, whatever palliative care think, patients do think that VAD is a valid part of end-of-life care and an option. And not for everybody, but for a select few. And 84% of our VAD applicants are already engaged with palliative care. They'd see no dichotomy, and they're actually very positive about their palliative care, which is why the things at the bottom that I'm talking about being rejected from palliative care are so bad, taken so badly, rejected by the doctors, or pushed out of the service, or having to move to another facility. Thank you.
Thanks very much, Charlie. And
Less
our last
than 5 minutes.
our last speaker is Mitchell Chipman, who is an oncologist and palliative care physician who is also a member of the Victorian Voluntary Assisted Dying Review Board. Thanks, Mitchell.
Oh, thank you, Paul. No need to highlight me because I'm just going to speak for 5 minutes briefly. I confess my profession and membership of the board, as Paul said, and it's nice to hear Cameron and Ian go through the law in clear thinking terms, which information should be well received by the community of practice. Now, since being involved with voluntary assisted dying prior to the Act coming through in Victoria, none of us were on the, as everyone knows, there were interstate people on an advisory panel, and then the Act was passed, and then we've been part of the rollout process, setting up the portal and what have you. And this is an extraordinary new service that the government and now our patients want basically the medical profession and nursing profession to provide, as well as, is he here tonight? Where is he? The pharmacist. He is here. Michael, as well as Michael's crew, doing an excellent job, I think. And the theme of my talk fits in as a professional, not a lawyer, having been familiar with the law to a degree, sat with Ian Freckelton for years on the board, so I'm not unfamiliar with acts and law, but even to me, I thought this is a huge deal. And when I practice medicine, I think, am I sure? All the time, am I sure? And when it comes to the issue of voluntary assisted dying, I am conflicted and can't participate, but I've been the support person for various practitioners doing it, particularly doctor administered ones. And it's been a very educative process for me. However, I am a cancer specialist and I do look after people, often from diagnosis to death, if that's what they want. And perhaps that's why I was chosen to be on the board. I've sometimes wondered. But when the issue is raised by a patient with me, and it often is, sometimes I think it's because of me and they know that I'm on the board. That's obviously should be irrelevant to them. But I gets asked early in my practice, and I record it in the history because they've raised it. I didn't coerce them, and there's a registration of that being raised, referring to Section 8, And I wonder how long that should really apply, because sometimes it's raised, in my opinion, way too early. And I wonder if the lawyers, if I could ask the lawyers what they think of how long an early and, in my view, inappropriate mentioning of voluntary assisted dying with respect to their case should apply. Then I have to think, Mitchell, are you sure this patient is competent? Do they understand their own health issues? Mitchell, is this patient being coerced? And I, in my practice, asked, how did you find out about this? And I hear that, unfortunately, sometimes it's, yes, oh, you're on the board, but often I hear they heard about it generally around the traps, as is expected, I think, by the law. Then if they are sick and VOD is on the reasonable horizon, in other words, I think they've got a 6 to 12 month time to live, very inexact science that, the first thing I examine is the patient being palliated properly? Are you sure the patient's being palliated properly? Cameron made an excellent point, I think it was last night, and said, what is the nature of your suffering? And very often the nature of the suffering is not related to the disease. The nature of the suffering might be related to the recent suicide of a daughter, or that was my most recent example yesterday. So we have to be very careful of the nature of the suffering, and that the disease that might kill them is related to the suffering, not something else. We've got to be very careful about that. To me, my personal view, and we've had a lot of personal views, my personal view is that voluntary assisted dying is a choice of last resort. It is when palliative care has failed. It's not when palliative care is inadequate because they live in the country. It's when it's failed. And we need to work toward improving that big gap. And I'm sure my palliative care physician colleagues, nurses, and every interested party will agree. If I'm asked about voluntary assisted dying, I say, am I sure that I can do it? Now, I know I can't because I'm conflicted at this point, but in the future, I will join the community of practice. And I've spoken to many practitioners as a member of the board, advising them about what the law means according to the lawyers that I've had at my disposal and their interpretation of it. That includes Betty King, Julian Gardner, Paula Shelton, who's with me, and other people as necessary. And I try and give the doctors some reassurance that they are protected and doing, we talk through the case and it sounds like they're doing the right thing. I think to myself, am I sure of the risks to my patient? What are the risks involved in being with the VAD process? And having been on the board, Charlie and I have heard a lot of encouraging stories, a lot of discouraging stories. And we've heard about those enough, so I won't expand on it. What are the risks to me as a practitioner being involved? Well, negotiating the portal is tricky, but improving. New process. That's a risk to me. It takes a lot of time, everybody. And those of you who aren't involved in the process need to take careful note of the community of practice. I think it would be very good if government could liaise with community of practice more in this regard. So I don't really have any more to say officially. I think I've asked a few questions of the lawyers and of the palliative care physicians. I would in particular like some comment from anyone about coercion and the early casual management of VAD, and does it count?
Thanks very much, Mitchell. That was good. So we've heard a range of views from both the legal perspective and the clinical perspective, and Mitchell gave a good commentary about the interaction between the two. We're now moving into a discussion, and Cameron and I are going to coordinate this. Cameron, I'm happy to for you to take over in whatever way you wish. And Jenny, Philip, you're watching the chat, and please draw our attention to anyone we need to invite to make a comment. Cameron and Ian, could I maybe start the discussion by asking both of you a direct question about Section 8? Ian talked about the different formulations in the different legislation in the various states. Which is the best one, and what kinds of recommendations should we make to the Victorian government when it comes to consider the possibility of amending or revising the Act?
Perhaps I should start there, and I'll keep it brief and see what Cameron has to say. I'm not sure anyone is quite engaged with the core issue. With the Victorian legislation, the problem is this unqualified preclusion on health practitioners raising the issue, even though they might get a strong impression that it is something that the patient would like to talk about and would like to receive information about. I think we need to get beyond that. It's quite patronising to require of patients that it be they who initiate the first conversation. And it's unrealistic psychologically, culturally, and in all sorts of ways to require that of them. I wonder if we're being a bit precious about that. It's certainly appropriate that we maintain an absolute preclusion and give an unequivocal message to all health practitioners, lest there be any who are evangelistic, and we can probably all think of some who have drifted in that direction, that they might encourage, exhort, or inadvertently put some pressure upon people to engage in voluntary assisted dying processes. So the message has got to go out that that is absolutely unacceptable, but I don't think myself that a corollary of that is the preclusion that exists in the Victorian legislation. I'd be really interested to hear what other people think, though.
I agree with Ian. I think the Section 8 is the antithesis of the doctrine of informed consent, which is an odd thing to put into a piece of modern legislation. My own personal favourite so far is the WA version. I think it strikes the appropriate balance, and it just includes it as part of a general discussion. I think to that degree, the New South Wales and Queensland provisions are fine as well. So to answer your question, Paul, and to agree with Ian, I think WA's probably got the best balance so far with that. I think all of the pieces of legislation need better language around what undue influence means, or voluntariness. There's a very old, long-standing doctrine of undue influence in contract law, but it's not completely opposite to medicine. And there's only a couple of English cases that touch on the issue, and they don't particularly do it well. And it's a New South Wales case called Patient Fay, which talks around some of the issues, but I think it would be of benefit to all of the pieces of legislation to actually set down not perhaps a strict or exclusive definition, but just a number of factors that might help the question, the delineation of the question of whether someone is being coerced, factors to consider, etc. So I think that's something they could all do better.
Maybe even just straightforwardly stating that in slightly more fulsome terms, that a practitioner is not permitted to encourage, exhort, or otherwise promote voluntary assisted dying in any way, directly or indirectly.
That might make more sense, because it's a statement of the intention, which could then perhaps be tested in practice. Could I ask other people to comment and maybe raise any questions? Cameron's raised the possibility of a request for a statement from the courts. Do you think there would be appetite in the clinical community for that? And would people come on board with that? Maybe I can ask some of the practitioners, maybe Balmick or Cameron McLaren, or you know, how do people feel? Do you think that's something we should be thinking of and trying to promote?
It's a very British approach to this. So if you look at the GMC, it will often go to the courts for these types of decisions. So it's not something that's been done in Australia.
Okay. James, a couple of people have raised their hand. Perhaps you can let them talk. How much would it cost, Cameron?
Oh, I imagine it would be just a day. And so I'm thinking around 30 grand. I don't know. Ian might be better off giving an estimate of costs. But I never charge for anything, so I don't know how much things cost. I always do everything for free.
Okay.
Something in that vicinity, yes.
Thank you. So the participants who raised their hands, so Mitchell and Alex, just butt in without, if you're panelists, just butt in without raising your hands. But go on, Alex, do you want to have a go?
You're on mute, Alex.
Sorry, I have a question following on from Mitchell's comment about last resort and tying it to the notion of the high proportion of people who are engaged in palliative care. Has there been any consideration given to making that a mandatory part of accessing VAD? Has that ever come up in discussions in any of the legislatures or states? Either to, I guess that's
Cameron,
a
was
question
that
either to Ian or Cameron.
Can I comment on that?
Yep.
Sorry, only that in the inquiries and the different discussions that went on prior to the legislation being tabled in Victoria, there was certainly significant discussion around this. And one sort of, there's potentially many, but one downside of that is that people sort of just come along to palliative care as a, you know, you just got to get a tick off for this, and it's not a, there's not much opportunity to have a very sort of thoughtful or considered sort of conversation or indeed relationship. So that was one of the sort of the concerns about that, that was a mandatory requirement.
We've got pretty strict criteria in section 9(1)(d) already. And you really don't want to be constructing extra barriers to people. It's such a hard conversation to have. It's such a difficult decision to make. We've limited voluntary assisted dying deliberately to certain scenarios. We've set in place all the checks and balances of which we're familiar about process to avoid people acting impulsively or without appropriate medical oversight and advice. I'd be a bit hesitant to construct a further barrier, but I'd be interested to hear what Mitchell and other clinicians have to say about it.
Could I ask Cameron McLaren, you're there, do you want to make a comment?
I'm sorry, I was scrolling my thoughts on the rest of the other points, and I've lost where we're about specifically what we're talking about at the moment. I'm sorry.
Oh, okay. We'll come back to you, Mitchell.
Thank you.
Yeah, look, going back to your original question, Paul, what would the appetite of the medical profession be about obtaining an opinion? Someone like Ian Freckelton going brief to the Supreme Court and getting an opinion about, say, coercion in this regard. I don't think the profession had any idea about how important that might be or what it might mean. And I think it all starts with, Ian, I'm sure you agree with me, we know each other quite well already. The profession doesn't understand what that process is. So I would say that before you could get a view, you would have to ask, you would have to explain what it meant and what the pros and cons were for in relationship to the practice of medicine. I'll limit my comments to that. Could I just make a plea that the first thing that I think needs to be sorted is the electronic carriage issue, which has been spoken about mainly by Cameron earlier. That's what I think we need to deal with prior to coercion in Victoria.
Okay, well, there are those two issues that Cameron and Ian drew attention to.
Yes.
Does someone else want to make a comment on the legal issues or legal obstacles? Deb,
Yeah.
I was going to get to you in a minute anyway, because we'll switch to focusing on some of the administrative obstacles, and you've got quite a story about your personal experiences, but why don't you make the comment you want to make now?
One of the comments I wanted to make, and good evening, everyone. I'm Deb Hartley. I'm a general practitioner. I've been in general practice for 30 years. I live in Geelong, which is outside Melbourne, so we cater for a lot of the rural and further afield places than just the metropolitan patients. And I've been involved in VAD since its inception in Victoria in June 2019. And I've done about 30 to 40 cases, so nowhere near as many as some of the VAD doctors that have been in Victoria, but still I've usually got one or two on the go at any one time. What I wanted to say was the offence to use the carriage service to incite suicide, to me, not only is suicide the controversial term here, but the word incite, which if you look up the Oxford Dictionary means to encourage or stir up violent or unlawful behaviour. And VAD is neither violent nor is it now unlawful. So I've always wondered why that sort of terminology was thought to be illegal from our point of view. And working in the rural and regional areas, I've had patients that have lived 2 hours away from where I live and work. And to go and see those patients is 2 hours there, 2 hours back, at least an hour with them. It's virtually half a day, if not a day. So it, to me, seems quite inequitable for these patients that they often don't get the opportunity to even access VAD because of where they live and because we can't do telehealth consultations over the phone. The second point is that even though I went into this role under the head of VAD as expecting to, I've got a special interest in palliative care, always have, so I've got a lot of elderly patients and I've got a lot of patients that I look after in the community that have terminal diseases. And so I went into VAD and did the training because I assumed that at some stage one of my patients might request it and I would therefore be prepared to help them through the process. As it stands, I have not had one of my patients requested, and all the patients I've had, which as I said is about 30 to 40, have been referred to me either by my colleagues in general practice or by the care navigators. And so the patients have brought up the subject of voluntary assisted dying with a person that initially hasn't been me. It's been the care navigator or their own GP. And they've been referred to me and I've made an appointment for them and I've either gone to their house or they've come to my surgery. And it's awkward because they think they've already brought it up with the initial person. I've never met them before, they've never met me before. And we've got to sort of have this roundabout conversation about what are you here for? And I've got to let them bring up that topic without potentially bringing it up for them. And sometimes it just doesn't work. So I sort of say, I understand you've gone to see the care navigator. Is there something you'd like to say about, you know, what you've talked about with them? And they get it then because they remember that that's supposed to have been the first thing they ask is, I want you to help me with going through the process of voluntary assisted dying. So that's just one of my points, or two of my points on both those legal aspects.
Okay, thank you. You've also made the point that it's that it takes many hours and you drive for 2 hours in either direction and get paid for an hour's work or something. So as a GP, it's not particularly financially rewarding. And that might be another obstacle to the smooth operation of the system. Sorry, Jenny Phillip. Yep.
That's all right. Thanks, Paul. I was just going to comment on Deb sort of talking about the dance around, sort of having to around the conversation, and there's just been some comments in the chat just to sort of, I guess, broaden the conversation a little. One from Jacqueline saying that if patients assume that a health professional wouldn't raise something unless it had merit, it's hard to see how you could raise VAD and perhaps avoid perception of pressure. And then I guess following that, Michelle Gold said that people need to be sort of fairly determined to get through the process, and that there's potentially lots of, if there was coercion involved, then it would need to be fairly sustained, and there could be many times when a person could waver. So they're just sort of, I guess, two perhaps interesting things that Cameron, you might like to take up.
Cameron McLaren, perhaps, and Cameron Stewart.
Too many Camerons.
Thank you, Paul. I think just to give my perspective on the telehealth issue and the carriage service is that, as Ian and Cameron will know, that the Criminal Code Act has 3 components to that section in order to commit an offence, and the third one of that is that the material is in, or the person intends the material to counsel or incite committing or attempting to commit suicide. Now, when a VAD death occurs, the VAD death is not reported to the Births, Deaths and Marriages as a suicide. So in my mind, a suicide doesn't occur. So I would like someone to try and prove to me how I intended a suicide to occur when a suicide doesn't occur.
Cameron, I can quickly answer that. The response to that would be, it's a federal law, and what the state law says doesn't matter. So, I mean, I agree with you, but that's what some of our colleagues are saying, that because there's a federal law that says that whatever the state law says doesn't affect it.
I cut in there, people, and say that the federal carriage law was somewhat of a surprise in the beginning, and it was a very conservative view that stopped practitioners being advised to use any telecommunications to do this. The practitioners have been advised not to. If they used telecommunication of any sort, it would require action to be brought and then a prosecution. And I think the risk of that might be very low. I'd like the view of the lawyers to say that, because to my knowledge, it hasn't been challenged or known to be challenged. But let's say a doctor decided to do telehealth as the coordinating practitioner. What do you think might happen?
Can I expand that question to include a point that Camille made, and that is that whilst there appears to be a definition or the possibility of offences, there's no sanctioned process, and there's not been any precedent yet in Victoria. Would the lawyers like to reflect on that?
I think that's right. There wouldn't be much appetite for bringing a prosecution. These things are always discretionary, and unless there was other aggravating conduct accompanying the use of the telecommunications, I think it's highly unlikely that a prosecution would be brought. The problem is that it's sitting there as a theoretical problem, and quite properly, practitioners are being discouraged from using that medium of communication accordingly, and they should be. They shouldn't put themselves in any jeopardy.
It's not discouraged, Dan. It is strongly, it is almost mandatorily no.
Yeah.
Perhaps we don't have to spend all the rest of the time on these two legal issues, and we can move on. There are quite a few other issues, and maybe Tanji, if you want to come in and talk about the work that you've been doing. But some of the other issues could include conscientious objection, and whether the conscientious objection process or provisions are working adequately. Cameron made a reference to that and raise some of the risks that are associated with that. So I'd be keen to know if people in the audience felt that that's working well. And there are other criteria such as the assessment of prognosis. We haven't really talked about that, but that varies across jurisdictions too. And there might be a question about, if we're talking about refining the Victorian law, whether that wording should be changed too. Tanji, do you want to jump in here?
Sure, Paul. I think just to respond to what Mitchell and Ian were saying, I think the threat of prosecution, however small, like even if almost impossible, is enough to stop people from doing it altogether. I think generally doctors are quite risk off as a profession and as a personality type. And I think in terms of, you know, your day-to-day use of drugs and things, you try to minimise your risk as much as you can, and that's, I think, what's happened here. So a bit of a 180 turnaround. Another thing that we've been working on is the financial considerations and the costs around voluntary assisted dying. And this stemmed from public debate and people saying things like patients with dementia have a duty to die because they place a financial strain on the healthcare system. And we've just spent, you know, the last hour and days before talking about how we shouldn't be coercing people. And obviously I'm not suggesting that this is reasonable by any means, but Paul did say to be deliberately provocative. It does come from the argument, though, that health policymakers often make, which is that we have a finite amount of resources for the healthcare system and we want to distribute our financial resources as best we can to get as much kind of bang for our buck as we can. So we want to make sure that the money, the things we're spending our money on, are giving us bang for our buck, I suppose. So financial considerations certainly form part of decisions around what medications and services get funded by the government, by the PBS and by the MBS. And these decisions often rely on cost effectiveness calculations, such as the QALY or quality adjusted life year. For those of you that aren't familiar with the concept, a QALY can be somewhere between 0 and 1, where 1 is a year of perfect health and perfect quality of life, and 0 is sort of dead, whereas decimal points are somewhere in between. And we wanted to look at whether and how we could use cost effectiveness calculations in the context of VAD. So we found a few issues with doing this. First of all, it's quite difficult to actually calculate the costs associated with VAD and any money potentially saved. So the argument in terms of costs of implementation of VAD, we have centralised services such as the Care Navigator service, the Review Board, the pharmacy service, but also the costs of individual healthcare services on workforce and training. And all of these services record or don't record costs associated with VAD differently. So it's very difficult to kind of get the fine granularity that you might need to calculate costs associated with expenditure. In terms of savings associated with VAD, the theory is that yes, you save money as a VAD patient because instead of the healthcare system spending its resources on costly healthcare at the end of life, this money can be saved because that patient is now dead. This is in itself quite complex because it relies on things like prognostication, which we know is uncertain and has lots of other methodological and ethical concerns, as does the QALY. So the idea that you can quantify a patient undergoing VAD would theoretically have a negative QALY, so their quality of life would be worse than death, and they would therefore be opting for death as a preference to their state at the moment. This on its own raises lots of concerns, such as how can we quantify suffering, not only physical suffering, but existential suffering, so psychological questions around dignity, loss of independence, all of those kind of issues that patients that opt for VAD are bringing up. but also, does a negative quality of life even exist? Does a negative number even exist? Is there a state of life that's worse than death? So diving into the financial considerations, while on the surface seems quite simple, actually we find that reducing these complex issues to numerical values really undermines what they mean and what the philosophy behind death and dying and living. So I'll just leave that there as kind of a provocation to see if anybody has any comments.
Thank you. Cameron Stewart.
Oh, Paul, I wasn't going to be provoked by Tanji. I was just going to raise an issue there that came up in the chat. Sorry, Tanji. And that was in relation to just some of the traditional words that are used, like incite, commit. And I can see how non-lawyers would say that's super offensive because it stigmatises suicide. And suicide is itself decriminalised, but the crime of assisting a suicide is a sort of, that's why that language is still used. They have specific meanings, those terms, aid and abet, incite, etc. So it's probably difficult to change those words in the context of the criminal code.
Thank you. Jenny Phillip.
Oh, I was just going to take up Tanji's point somewhat bravely and think that it's interesting. I think that costs are almost unspeakable in this sphere and very challenging. Sometimes, the argument sometimes made that palliative care saves money for people at the end of life compared to, intensification of treatment at the end of life. I don't know the relative resources that are available or provided when people undertake VAD versus other forms of care, it's interesting that sort of it's such a difficult conversation to even raise. I'll just stop there.
Well, as someone trained in economics, I mean, I think the problem with using economic arguments here is that they only really work one way. If it was shown that VAD was incredibly expensive and only helped a very small proportion, I think most people would go, well, we shouldn't do it, or it shouldn't be encouraged, or whatever. But if you did say that it was economically beneficial, you're still not going to win the argument there, because then you're going to come across as someone who's not valuing human life. So I think you're in a bit of a hiding to nothing when you're using economic arguments, even though I'm a strong supporter of health economics.
Yeah, I mean, there's an interesting analogy that we probably can't go into in detail about organ transplantation, which is much cheaper than managing people, say, for example, on dialysis, which is one reason the governments have adopted a very moral point of view and tried to promote it. Cameron McLaren's point raised the question about the residency requirements and whether they're necessary anymore, given that all the states now provide for voluntary assisted dying. So maybe that's an obsolete provision that could be removed if really essentially the legislation is more or less equivalent around Australia. Would anyone like, Cameron Stewart, would you like to comment on that?
Yeah, I agree. The only thing I might be thinking might be problematic is the cost implications. Just as some states might not want to have to pay for non-residents. Again, coming back to cost there, it's probably, I'm blaming you, Tanji, for this. Yes, so I'm not sure. Obviously there's no Medicare scheduling for this. So a state government would have to pay for it. And if people were coming from other states, but again, normally mutual recognition and other things for those things would normally solve that problem. So I don't think there will be, I agree with Cameron, I don't think there's going to be euthanasia tourism now, VAD tourism. It's not going to happen, except perhaps from the territories.
Can I ask people what they think about conscientious objection here? Maybe Ian Olver, you'd like to comment. So people obviously are not forced to participate, medical practitioners are not forced to participate, but nor are they compelled to ensure that patients who are seeking voluntary assisted dying have the means available to them to exercise their legal rights. Is that wrong?
No, I think it applies to other situations, and the ideal would be if a conscientious objector felt that referring on to a practitioner that would carry out voluntary assisted dying or abortion or whatever it was, if they objected, would be the ideal situation in a sort of a patient-centred care sense. Just make one comment on the financial thing, although it's always very difficult, that if you've been arguing against the voluntary assisted dying or euthanasia and so on, one of the arguments that's made is that the most problematic type of society to bring these sort of laws in is an economically rationalist society.
Do you want to just elaborate a little bit on that?
Oh, well, actually I will on Monday, but the reality is that the things we value most, if you like, and the hierarchy of things we value in an economically rationalist society where life is valued perhaps less than other considerations, such as economic considerations, then that would be the one that would liberalise the restrictions around euthanasia. And I think what we've seen from the countries that have had it for decades, of course, and I'm not going to go into arguments about whether you call them slippery slopes or evolution, but most of them have significantly liberalised the sort of people that can apply for voluntary assisted dying. So that's an end point that occurs, maybe 20 years later. But it's interesting that that end point has occurred in Canada and Belgium, as we heard the other day.
Thanks. Jenny, Philip, are there any people that we need to bring in from the chat?
I think most of the things have been at least covered or touched on some of the points that we've been making around citizenship and coercion and moving interstate, the issue around boundaries. So I think we're fairly okay, Paul. I guess I was just going to, if I may, take the point. I was going just to raise that we've been talking or touching on the issue of equity of access to VAD, and that comes under the carriage laws, etc. I do think that it does need to be tabled that there is and continues to be an issue about access to other forms of care, including palliative care, and that's not equal or available in Victoria, although it's not affected by the carriage laws, I guess.
And the inequity of access also applies to the difference between urban and rural patients, just as much to any other form of care as it does to voluntary assisted dying.
Yeah, indeed.
What about, can I ask about the prognosis issue? In the Victorian Act, there's a requirement for a 6-month prognosis or 12 months in the case of neurodegenerative diseases, but we all know that that's the calculation or estimation of prognosis is highly unreliable or imprecise. Is that a mistake or an error, a lapse in the law? Again, maybe Ian Freckelton and Cameron Stewart, would you like to comment on that, or anyone else who's got some thoughts on it?
It was part of a compromise process, wasn't it, to reassure that there wouldn't be a flood of people, including people who were not in jeopardy of passing away for a lengthy period of time and might therefore have been motivated by factors other than imminency of death. They're very arbitrary provisions. The point's been made already that in other countries where voluntary assisted dying has been in place for some years, there has tended to be a liberalisation of these kinds of criteria. And the reason for that liberalisation has generally been that in the jurisdictions where it exists, because of the checks and balances, the community has become reassured that the potential for abuse is low, and therefore they've been prepared to reduce the checks and balances in place. I would suspect that we will be in a similar place in a decade's time.
I would only add to that it's been partially accelerated in Canada, where they've unhooked terminal illness and they've gone more to the Benelux kind of suffering model, mainly because of constitutional challenges that are possible because of the Canadian Charter of Rights and Freedoms. It could be possible you could mount something like that, I suppose, in Victoria, where there is a charter as well. So there's a potential for those types of legal arguments to be made. But of course, that legislation can also be overridden by Parliament too. So the Parliament might be, the courts might say these laws should be reconsidered in light of the right of privacy or whatever, but the Parliament still has the power to say, no, this is what we want, even though you're telling us it's a breach of a human right.
Okay, now we're sort of running out of time. We've got comments from Charlie Corke and Cameron McLaren, and then Jenny Phillip, and then Jenny's going to give a bit of an overview and wind up. Charlie.
I was just going to contribute that Queensland has a 1-year time for everybody, rather than having the 6 months for everybody and 12 months for neuro diseases. And it seems to me to be a logical thing, because it would remove some of the issues that we're seeing around that panic around delay and trying to get it done early, and it would maximize the time that people had it and sat on it and didn't use it, but felt reassured by it. So you'd potentially take away that differentiation, and also, of course, it would, if everybody went to a year prognosis is a lot easier. There's a lot more data around year prognosis than there is 6 months prognosis, and it would certainly make it a lot easier, less fraught to get people through the process. So I think that it'll be interesting to see what Queensland does and whether we follow it.
Cameron McLaren. Thank you, Charlie. Cameron McLaren. Cameron,
thank you.
Yep.
Yeah, thank you, Paul. So I just wanted to raise the issue of permits. Now, particularly this is pertinent when people have their oral medication and then they lose the ability to ingest orally or safely ingest orally. And the turnaround time is limited by the legislative requirement that the medication be returned prior to the application for a practitioner administered permit. Now Michael's team is very good at retrieving that medication, but that won't happen on the day. That might happen 2 or 3 days' time. Once that medication's returned, then we apply for a new permit, which might take another 3 days to come back, and then we need to reschedule another delivery of the pharmacy for another 2 to 3 days' time. So we're really talking about the extension of at least a week for many of these people who have to switch between permits at a time when they've lost their ability to swallow, and that's a very long time for sarcopenic patients at the end of their life, and many patients it's just not possible. So I don't think that that's functioning as a safeguard. I think that's functioning as a barrier. I'd like to see either the permits move away from the legislation and into the regulations so they could be managed or altered easier, or the permits allow for the permit to be to encompass both the self and intravenous protocols, so that this changeover could be quite streamlined. I think that's a really big issue for me. Some of the other issues, I think there's many other issues within the legislation, such as the role of the contact person in practitioner administration cases. There really isn't one, and it doesn't need to be there, and it adds extra stress onto the family member who volunteers as the contact person. Although it's a minor role, and we stress that it's a minor role, it's not perceived as a minor role by some who uphold it or take it on. So I think that can be reviewed as well.
It's Mitchell. I might just.
Hi, Mitchell. Yeah.
briefly say that the contact person can be in serious breach of the law if there is substance unreturned in the required time frame. So it is onerous, or can be onerous.
It is, but in the case of a practitioner administration where the intravenous medication is dispensed to the practitioner and they're never in possession of it, so it's completely superfluous.
Okay, thank you. That formulation of the distinction between safeguards and barriers is really quite an important one. Obviously, it can be very delicately balanced. So I'm just going to hand over to Jenny Phillip to make whatever comments you would like to make, Jenny, and to give a little bit of an overview and bring the session to a close.
Thank you, Paul. So thank you. It's been a really rich discussion. I think many of the issues touch on the issue of equity, not least the carrier service discussion that we had at length at the beginning. And it's clearly something that was thought up pre-COVID and after telehealth, that sort of put in a whole additional sort of lens on using carrier services for all sorts of clinical care. And key people are disadvantaged by that. I think the equity issue is interesting with relation to prognosis as well, because it's obviously much easier to formulate a 6-month prognosis in many situations of people with advanced cancer than it is for someone with perhaps frailty or airways disease. So I think that it is interesting that maybe that's behind the higher numbers of people with cancer that are accessing legislation. The discussion around coercion, thank you, very thought-provoking, and how the practitioner could raise this in an open conversation, listing a series of options, and how the skill in doing that to avoid coercion or perception of persuasion while still giving information and fully informing. And then I guess the other big area that we really talked about was the resident status of people. And now that most states have this legislation in place, then the issue about that seems to be much less of an issue, and the tourism issue is clearly something that was discussed as being perhaps important to review. So a rich discussion, thank you, and thank you particularly to the panelists that spoke. And I'll hand back to Paul to close. Thank you.
Okay, thanks, Jenny, and thanks everyone for a vivid, intense and wide-ranging discussion, which I think was ultimately very productive. Our next workshop is next Monday, so you've got a little bit of a holiday between now and then. It's 5 o'clock, same time, and we look forward to talking with you again then. Thank you everyone for your attendance and your contributions, and good night.